policy. A title defect might involve unpaid taxes, liens, an undisclosed claim from an heir of a prior owner, or even an easement from a local power company. And I want to take a moment to talk about easements because that's a big title claim here in Arizona, where we see this come up a lot. We get a lot of cases on easements, being a real estate law firm. And it's important to note that when most people think of an easement, they think of a recorded document. They think of a recorded easement. It might say declaration of easement or easement at the top. It's recorded. And most of the time, a recorded easement won't necessarily present a title issue because the title company will have known about it and uncovered it in its title search, and it would be disclosed on the Schedule B exceptions in the title report. And so the buyer would also be aware of the easement. And so what we see a lot in Arizona are undisclosed easements. And so you can also have, for example, what's called a prescriptive easement. A prescriptive easement is similar to adverse possession, where someone is occupying property for a period of 10 years. However, it's not based on a recorded document, and it's not based on permission of the servient property, of the property being occupied. And so the most basic example would be, let's say you're occupying a gravel driveway to access your home every single day through your neighborhood. And that gravel roadway is actually owned by your neighbor. If you're utilizing that for over a period of 10 years, you can actually go into court and say, Judge, I've acquired a prescriptive easement over this gravel driveway, and I want to continue to have the right to use it as I have been over the past 10 plus years. And if you prove your case, the court will award you that property right, that prescriptive easement. It's important to note that prescriptive easements are different than adverse possession because you're only awarded the right to utilize the property. You actually don't have ownership of the easement property. You just have the right to utilize it in the same or similar way that you had been in the past. So that's how prescriptive easements are formed. They're not recorded. It's based on use. Generally, title policies, you'll of course want to confirm this, but generally title policies would not cover such a claim because title insurance covers recorded documents. They cover defects from the title search, mistakes in the title search, problems with chain of title. And someone coming out of the blue with a prescriptive easement claim would not be something that a title company would be aware of at the time of issuing the policy. But if you want coverage for that, those questions should be posed to the title rep to see if an enhancement could be obtained or an extended policy. Same thing with adverse possession claims as well. And I'd like to now give everyone kind of another real life case example of a case I handled and it went to trial, where title insurance can actually be used as evidence and come into play and affect the outcome of the trial. So as a real estate lawyer, when you take out a title policy, the title policy will tell you what is covered, but more importantly, it will also tell you what is not covered. So the title policy will have what are called Schedule B exceptions. And the Schedule B exceptions are generally recorded documents that are accepted from coverage. And so those need to be read by the insured to understand what is not only what is covered, but what is more importantly not covered. And the Schedule B exceptions can be used in trial to demonstrate that the buyer of property was aware of certain recorded documents. So a few years back, I handled an implied easement case, and an implied easement is another type of easement that can be obtained other than prescriptive easement, where it's not in the recorded chain of title. And so oftentimes in Arizona, what will happen, a property owner will split out lots, or maybe a property owner owns two contiguous lots and wants to sell one of them. And as a result of that sale, one of the lots ends up being landlocked because maybe the owner, when the owner owned both lots, the owner could have an access route to the two lots. But by selling one of the lots, now that lot that either got sold or the lot that got retained no longer has direct access to their property. There's a doctrine in Arizona called the implied easement doctrine, where by implied way of necessity, if you prove to the court that at the time of the severance caused your lot to become landlocked, you may be able to obtain what's called an implied easement. So we see a lot of these cases in Arizona. And so I handled a case where two lots up in the town of Cave Creek were owned by the same owner. The owner sold out the north lot, and consequently, the argument he made in court was that his lot became landlocked. So he actually arguably landlocked himself. He had access. He sold out the north lot. The north lot had access. His south lot then lost access. He later tried to obtain a voluntary agreement to get a new easement from the north lot and the other surrounding lots. He couldn't do that. He then had to sue. And one of his primary claims in court was that he was entitled to this implied easement, because when he sold the north lot, his lot arguably became landlocked.
So Ben, in that case, if he was smart and planned ahead and met with an attorney before consummating the sale, he would have gotten the easement on his own land before he sold it, right?
Absolutely. So clearly, in most of these cases, to be honest with you, it's funny because we, as a real estate law firm owner, I go out and I try to tell everyone, please hire me. But the vast majority of our cases resulted from no lawyer being involved. Right. So maybe I should say, don't hire me, and then I'll just get the case, 7 months later.
Or as they say, hire the attorney now, or you'll hire him later.
Yeah. So, you're absolutely right. But here's what was really interesting about this case. There was a recorded lot split that actually, in the seller's defense, there was a recorded lot split that actually demonstrated or showed that he had access out of his property to the east. Mm-hmm. However, the south owner in court, and this is like 20 years after he conveyed the north property, the south lot owner in court, he claimed, no, that 2003 lot split was technically invalid. And he was able to prove that. So he's able to say, hey, it was technically invalid. So therefore I had no legal access. Yes, there was this recorded document that showed I had legal access, but I had no legal access. And when I was examining this party in court, the south lot owner, I had the title policy. And I said, wait a minute, your argument to this court is that you're entitled to an implied easement because at the time you sold the lot, you were landlocked. I said, well, wait a minute, let's look at page 7 of your title report. Here are your Schedule B exceptions. Do you see item number 6? It's the 2003 lot split, and it has the recording number. And he says, yes, I do. And I said, this is your title policy. You obtained this at the time of the conveyance. And he said, yes. And I said, so you were aware of the 2003 lot split at this time in 2003, and then juxtaposed to that, I had the blow up of the lot split, and I said, and the recorded lot split shows that you had access. So so the court bought that argument. That was persuasive to the court and the Court of Appeals. So the Court of Appeals ultimately said, we're going to deny your implied easement